If you're in the NFT space, you need to hear about a recent case that impacts what we are creating as our NFTs to make sure that you're legally protected and you're not encroaching on anybody else's intellectual property. Today, we're talking to everybody's favorite IP and entertainment lawyer to learn more and how it very well could apply to every single thing we are creating in the NFT space.
Hi, my name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that is dedicated to all things intellectual property.
Tony, you talked about a case on your TikTok and Instagram recently that ended with the phrase, the rules of IP that apply in the physical universe equally apply in the digital universe. And I want to break down why this is such a valuable case. So can you tell us about this case, what happened, and what this actually determines by the outcome?
Yeah, absolutely. So this was a lawsuit that Hermès had filed against Mason Rothschild, who is an artist that created an NFT collection called the MetaBirkins collection. So the essence of MetaBirkins was that at the end of the day, there are these little NFT goods that were out there and they looked fuzzy, but they bore an identical resemblance to Birkin bags themselves.
Mhm.
Now, the thing with that is Birkin is registered as a trade dress in the U.S. Patent and Trademark Office. So that means that what Hermes is trying to protect is the overall design of the Birkin bag, so that if you looked at it without the Hermes logo, without any reference to Hermes, you would know that that bag stems from Hermes. That is indeed a Birkin bag. It's not a Michael Kors. It's not a Coach, Louis Vuitton. It's specifically Hermes. And that's the essence of trade dress. Trade dress is all about product design, packaging, decor, uniforms that are used to further the source identification of goods or services. So, of course, Meta Birkins look like Birkin bags. They're fuzzy, but of course they're NFTs, so they're digital goods. They're not physical goods.
Right.
But in the eyes of Hermes, they thought that this could cause consumer confusion because the name is called Meta Birkins. And of course, when you have a bag that looks like the Birkin bag itself, surely it could cause some type of consumer confusion. So they filed a lawsuit against Mason Rothschild alleging trademark dilution, meaning that it would likely blur some type of or impair the association between the Birkin bag and Meta Birkins to the average consumer. And they also sued on the basis of trade dress infringement as well as cyber squatting because Meta Birkins had metabirkins.com as their URL. So this was filed last year. I think it was like January of 2022. Case just finished. It was about a week and a half long. And basically, Mason Rothschild argued, hey, I'm protected under the First Amendment because this is free expression of art. This is not an infringement of trade dress in any way, shape, or form. I'm not doing anything that warrants some type of violation under trademark law. Of course, Hermes says, not so fast. We have the proof in the pudding. And certainly they brought an argument of consumer confusion to the forefront. And not to mention, it was very interesting. There was actually evidence that came forth where Mason Rothschild seemed to be less concerned with artistic expression and more concerned about basically making money off of intellectual property that belongs to somebody else. That was evidence that came out in the course of the trial. So, of course, the 9-person jury agreed with Hermes in this case. They argued that this was trade dress infringement and trademark dilution. But this is a paramount case because first, this is the first lawsuit that we're seeing from start to finish that involves an NFT collection that is violating some aspect of intellectual property law. That's number one. Number two, this, as I said in my video, and you said it at the start, and I'm going to say it again, this underlines how the rules of the physical universe equally apply in the digital universe, meaning in the real world, I can't make a Birkin bag because if I make a Birkin bag, I'm going to infringe on the trade dress for Hermes. That's how all the Canal Street vendors that are selling illegal handbags are getting caught because they're violating clear trade dress of not just Hermes, but Coach, Louis Vuitton, all the others. If I can't do it there, what makes me think that I could do it in the metaverse in Web3? I can't, honestly, because I don't have the proper permissions. I never licensed the right to use Birkin bags in that capacity. It would be wholly reckless for me to go ahead on OpenSea or any other NFT platform and start making Nike NFTs if they have the Nike logo on it. If I'm using it in that manner, it would be wholly reckless for me to start using the Louis Vuitton logo in that capacity as well. So the bottom line is that it's very, very, very important for people to know that yes, the NFTs are a new space, and certainly at one point we were saying, oh, it's the Wild Wild West. Do the rules of copyright of the Copyright Act or the Lanham Act for trademark law, do they all apply to NFTs and the metaverse? I said it before, I'll say it again. Absolutely. Who said that there was any ambiguity there? It clearly does. You're misappropriating it in some fashion. I mean, if we were having the same argument about copyright infringement with Napster once upon a time, when there were people that could illegally download music off those platforms, and it was a new medium, what's not to make me think that that's the exact same situation that could exist here, in my opinion? So this is such an important case. I love that this outcome happened. I think it's good for brands because it just reinforces that there is a world where they can protect their brands in some robust capacity, even in the Wild Wild West, which is laughable. I'm calling it that, but there's that. And more importantly, like, this just underlines that if any NFT collection out there wants to do this type of thing, tread lightly, or maybe bring a better argument for artistic expression, because Mason Rothschild was not able to do that, unfortunately, in this case. So this is an incredible win. I fully expect an appeal, but for now, this is a nice, solid win for Hermès.
So there are two big takeaways from this that we need to make sure we are pointing out before we go today. It is incredibly important to not infringe on anyone else's intellectual property rights. You cannot be using someone else's logos or designs in your NFT collections, in your NFTs that you're making. And if you are confused, if you're uncertain, if you're not sure if you're going to be allowed to do something, my favorite piece of advice is to check with your lawyer. Your lawyer is going to be able to look at these things and very clearly tell you if you have the ability to use something or if you could be facing an upcoming court case. So we always want to make sure that you are not infringing on anybody else's rights and you are checking with your lawyer if you do have a question. Tony, final thoughts on this?
I'm just going to say straight up, I think that the whole First Amendment free expression argument is a bit of a stretch when you're in this NFT space. And so I caution people to use that argument going forward, because I think what also got tripped up in this case was that Mason Rothschild was comparing him to Andy Warhol. The difference was that, well, one, the Campbell Soup CEO loved that this was free marketing for them, so they sent him like a practically lifetime supply of soup cans as a thank you. But number two, that was art, because did you ever see Andy Warhol sell his artwork to millions of people? There's something to be said about free expression under the scope of art when you're purely doing it for that reason versus making commercial profits off of it. That's exactly what happened here. If you're an NFT creator listening to this video, I caution you very, very strongly to think twice if you're in this space of making art and making money off of that art that bears the likeness of some type of trademark or copyright that clearly belongs to somebody else. So, you said it, Cam. If I could, I would scream loudly in this room, but I won't. Contact your lawyer. Contact a lawyer for their guidance, because they know they're going to give you the best guidance and they're going to work in your favor. And if they're not honest with you, go find another lawyer, because I'm telling you right now, there's no world where you can go ahead and make an NFT collection that has every single luxury brand logo and you think you're going to get away with it. Sadly, that is not going to be a case. So come up with something inventive. Be creative for once.
There we go. Make sure that you are staying in your own creative lane. And if you've got questions, reaching out to your lawyer. If you've got questions on other NFT related things, feel free to drop those questions down below. Tony is coming back for more episodes and we would love to get your questions answered. But if you can't wait, you can always reach out to Tony on his social media, where he is helping us stay legally protected in the entrepreneurial space, in the IP space, in the entertainment space every single day. So Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor.
If you have questions, go ahead and drop those down below, because we are here to help you grow inside of your business in the Web3 space, in the NFT space, and beyond. And we want to make sure that we're bringing on the best experts to help you grow in whatever space you happen to be in. Drop those questions down below, hit the subscribe and notification bell as we help you to continue to navigate the world of social media marketing, growing your online business, and making more money online, but spending less time doing it. We'll see you in the next episode.